Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we are dealing with a recent court decision that involves a group of officers that killed a suspect. Now, in this particular case, this suspect was thought to be on drugs and might have been undergoing excited delirium and was being somewhat uncooperative with the police. The person was put in handcuffs and then lied on the concrete in the prone position. One of the officers put his knee on his back and on his neck for several minutes, which caused positional asphyxia, as 3 other officers might have assisted in the process. And if this sounds familiar, it really shouldn't, because you've never heard of this case before, because this would be the estate of Jesse Aguirre versus City of San Antonio. In this case, all the things I just said happened, and we're going to learn a little bit about whether or not the officers are entitled to qualified immunity. Let's get started with this. In the early evening of April the 12th of 2013, the San Antonio Police Department received complaints from motorists that a man, who appeared to be mentally disturbed, later identified as Jesse Aguirre, was walking and waving his hands near the median of Highway 90. The first 4 defendant officers that responded to the complaints, Gonzalez, Mendez, Morgan, and Anarando, arrived in separate vehicles on the eastbound side of the expressway opposite where Aguirre was walking eastward towards the median of the westbound side. Gonzalez was the first to arrive. She left her vehicle blocking the leftmost eastbound lane and approached Aguirre on foot with her firearm, pointing at him, ordering him to come here and threatening, "I'm going to shoot you, MFer." When Aguirre did not acknowledge the command and continued to walk, Gonzalez stepped over the median and followed him. Soon thereafter, Officer Morgan, pointing her gun, and Officer Mendez, pointing his taser, also approached Aguirre along the eastbound side. Aguirre then stopped, bent forward, and placed his hands on the median. Gonzalez rushed forward, grabbed Aguirre's arms, and handcuffed Aguirre's hands behind him while he remained bending over the median. According to video evidence, Aguirre did not resist being handcuffed. While handcuffing Aguirre, the officers noticed he had fresh needle marks on his arms, indicating that he recently used drugs. So we've got 4 officers arrive on the scene of a man who is acting strangely and is not obeying directions of the police. The officers arrest him or put handcuffs on him behind his back and then see needle marks, raising the knowledge in their mind that now they believe this person might be on drugs. So now they have a person who is probably used drugs very recently, who is resisting arrest, and they have put handcuffs on them. So what happens next? After some additional officers arrived, the 4 officers in question assisted in moving Aguirre from the car hood to the ground onto his stomach next to the median, with his hands still cuffed behind him. The video does not show Aguirre resisted during this maneuver, but instead that he stumbled with the officers toward the median. After Aguirre was placed prone on his stomach, Gonzalez pushed his legs up and crossed them near his buttocks and kneeled forward on Aguirre's legs, holding them near Aguirre's bound hands in a hog tie-like position. Officer Mendez knelt with one knee on the ground and the other on his back, later changing the position to hold Aguirre's shoulders and cheek down against the pavement with his hands. Officer Mendez testified that he is using part of his body weight to hold Aguirre down, thus applying pressure to Aguirre's back and neck. So yes, as I mentioned in the introduction, because I tell the truth, right? This officer, yeah, he's got him handcuffed, and at the point he's handcuffed laying on the ground, he's no longer resisting arrest. And the officer, according to his own testimony, has his knee on his back and his neck as he's handcuffed in a hog-tied position with the officer's weight on his back and neck. What happens next in the story? The officers held Aguirre in a prone position for approximately 5.5 minutes, and during this time, Aguirre stopped breathing. After the 5.5 minutes had elapsed, the officers noticed that Aguirre was no longer breathing or responsive, and they turned him over onto his back and removed the handcuffs. Juarez jogged to the trunk of his car to retrieve medical equipment. At this point, the officers appeared to be in good spirits. According to the plaintiff in the dashcam video, Juarez can be seen smiling as he jogs to his vehicle, and several other officers likewise appear to be smiling and laughing as they wait Juarez's return around the body. So even though this person is no longer breathing, even though this person is apparently now dead, they are laughing and joking amongst themselves about apparently how happy they are. So that's great. Juarez returned at a walk with his medical bag approximately 1 minute after he left. Aguirre remained unresponsive, leaving to Mendez to perform a sternum rub in an unsuccessful attempt to respond to rousing. When this and similar techniques proved unavailing, EMS was contacted, finally, and one of the officers began to attempt CPR, but stopped after only 20 seconds. So, yeah, this case is sounding suspiciously very familiar, but for some reason, this case didn't get the press. I wonder why that might be. But yeah, this officer had this guy down on the pavement, on his stomach, handcuffed behind his back, with his body weight on the guy's neck and back for 5.5 minutes, as the guy died from positional asphyxia, as 3 other officers also helped. So that's a whole series of things that happened. Yeah, and then once he died, and one of the officers decided to get his medical bag, the other officers are laughing and smiling, and the other officer who went to get the bag apparently walks back, not runs, mind you, but walks back, and then one of them does CPR from 20 seconds and stops. So it's going really, really well here and in Texas, so that's happening. The officers were ultimately unsuccessful at reviving Aguirre. A subsequent autopsy revealed and concluded that the position in which officers had placed Aguirre had caused him to asphyxiate. Positional asphyxia, due to restraint by the police, and this is classified as a homicide. The plaintiff's medical expert, Dr. Brant Milter, who reviewed, among other materials, several medical reports, photographs, and autopsies, as well as the officer's statements by Aguirre's girlfriend, who also happened to be there at the time, and the officer who interviewed the officers during the incident, and dashcam videos, opined about known dangers in which the officers had placed Aguirre. The position involved pressure to Aguirre's back and to his neck, and his legs were pulled backwards in the prone position over the course of 5 minutes. Dr. Milter also cited, and the plaintiffs introduced into the record, a bulletin published by the United States Department of Justice that was provided to local law enforcement in 1995 addressing dangers of positional asphyxia precipitated by cocaine-induced excited delirium. Where have we heard that term excited delirium before? A condition Aguirre was suffering from according to his autopsy. Notably, the bulletin recommends against the use of a maximally prone restraint technique when excited delirium is evidence, as according to the bulletin, this factor is found frequently in deaths involving positional asphyxia, including the one in question here. Aguirre's estate and his widow, Blanca Aguirre, on behalf of herself and his next friend of their child, brought excessive force, deliberate indifference, failure to train, and a Texas tort claim against the city and defendant officers. So, yeah, the family wants to sue for this wrongful death due to excessive force. And so they have to sue the police because, they were never charged, and they have to sue. And we have to figure out whether or not we can sue these people or not. So let's figure out whether or not these officers can be held responsible for the 5-minute-long knee-on-the-neck positional asphyxia death. Let's read more. Under the doctrine of qualified immunity, government officials performing discretionary functions are generally shielded from liability for simple damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. We begin with the first prong of qualified immunity, considering whether the plaintiffs have raised a genuine issue of material fact regarding whether Aguirre's federal rights were violated. When a plaintiff alleges excessive force during investigation or arrest, the federal right at issue is the Fourth Amendment's right against unreasonable seizure. Today, the Fourth Amendment provides protections against an officer's use of excessive force to effect arrest or seizure, citing a case which maybe you never have heard about. You may have never heard about this case called Graham v. Connor. Ever hear of that case recently? Yeah. To prevail on an excessive force claim, the plaintiff must show an injury that resulted directly from an officer's use of force, and the force was objectively unreasonable. In this case, it's undisputed that Aguirre's death is sufficient injury, and that resulted from the officers placing him in this maximal restraint position. Our focus is therefore on the third element, unreasonableness, or the excessiveness of placing and holding Aguirre in the prone, maximal restraint position under these circumstances. To determine whether an amount of force is excessive, we must balance the nature and quality of the intrusion on the individual's Fourth Amendment interest, against the importance of the governmental interest alleged to justify the intrusion. Excessive force claims are necessarily fact-intensive. Whether the force is used is excessive or unreasonable depends upon facts and circumstances that are particular to each case. In making the determination, a court should consider the totality of circumstances, including severity of the crime at issue, whether the suspect poses an immediate threat to safety of the officer or others, and whether they're actively resisting or attempting to evade arrest. When evaluating these factors, which the Supreme Court set forth in Graham v. Connor, we keep in mind the reasonableness of particular use of force must be judged from the perspective of a reasonable officer on the scene. As to the first factor, defendants do not attempt to show the severity of any crime committed by Aguirre weighed in favor of the level of the force used by defendant officers. So his crime, at the time that they arrested him, was walking on the highway. So that was what he was doing. Apparently that was illegal. In fact, and also he was kind of acting strange and weird, but, walking on the highway, basically. In fact, defendants do not articulate any criminal investigation function justifying their actions, and instead rely on the existence of a threat to public safety, namely the potential danger to a motorist and himself that Aguirre's mental disturbance and walking along the median of the 8-lane highway crossed. Yeah, so he's walking along the middle of an 8-lane highway, so that may not be necessarily safe. And at most, the crime at issue is a traffic offense. Yeah, so he's, it's a fairly minor crime, all things considered. But, yeah. The defendant officers maintain on appeal that Aguirre's attempt to break free posed a substantial and immediate risk of severe physical injury or death not only to defendant, but also to innocent civilians. In their declaration, the defendant officers state that Aguirre was resisting, and they fear that he would break away and run into traffic, causing a dangerous collision and potentially dragging one of the officers with him. But the plaintiff's summary judgment evidence and this court's own review of the video evidence at minimum raised genuine questions about whether it was objectively reasonable to believe that he was resisting or even physically capable of posing an immediate safety risk that would justify the use of extraordinary dangerous force by placing and holding him in the prone maximal restraint position that led to his death. So, somewhat like the Floyd case, the officer's story may have been contradicted by the video evidence. So the officers say, well, he was resisting when we had the cuffs on him on the ground, and the video evidence seems to belie that claim by showing, actually not so much with the resistance. So the district court's like, that doesn't seem to be borne out by this, so yeah, that doesn't seem right. Plaintiffs, who were the non-movements in this case because the officers were the one who moved to dismiss, contend that Aguirre was not resisting and he did not pose a significant danger to the officers, the public, or himself at the time the officers placed him in a maximal restraint position. Rather than utterly disregarding the plaintiff's version of events, the video shows that traffic had slowed considerably by the time the officers bent Aguirre over the patrol car hood. At this point, at least 5 officers were holding Aguirre motionless over the hood, and several more were standing few steps away. This period of apparent calm before the officers brought Aguirre to the pavement next to the median calls into question the officer's testimony that Aguirre posed an ongoing threat of serious bodily harm to the officers or others. Our review of the videos also does not indicate that Aguirre was resisting, struggling, or at all uncooperative when officers walked him over to the hood of the car. It is best unclear from the video whether they or how much Aguirre was moving once he was bent over the car. The video very nearly confirms there was no resistance. To summarize, the first Graham factor, the severity of any crime over which Aguirre was suspected, weighs in favor of it being unreasonable and excessive for the officers to hold Aguirre in the dangerous maximally restrained position for 5.5 minutes, and there are at very least genuine disputes as to 2 other Graham factors as to whether Aguirre posed a safety threat to the others or officers, or was resisting the officers' efforts to remove him from the highway and hold him until a police wagon could arrive. Plaintiffs argue that officers placing and holding Aguirre in the maximally restrained position was excessive and unreasonable application of deadly force. Claims that law enforcement unreasonably utilized deadly force are treated as a subset of excess force claims. The testimony of plaintiff's medical expert, Dr. Brant Mittler, evidences that substantial risk of death or substantial bodily injury posed by officers' use of the prone, maximally restrained position under the circumstances that were present here. Dr. Mittler's detailed in his report restraining Aguirre in that position, face down on the pavement, with his hand cuffed behind him, as leg bent up and back onto his buttocks in a hog-tie-like position, and applying any force sufficient to maintain Aguirre in that prone position, was substantially likely to, and ultimately did, cause his death. The prone position and pressure applied to neck and back more likely than not restricted Aguirre's ability to expand his lungs and oxygenate his blood, and more importantly remove carbon dioxide and maintain a normal pH in blood. The bending of Mr. Aguirre's legs in the position that were held while he was in the prone position reduced venous return to the heart and reduced his cardiac output. The pressure applied to Mr. Aguirre's back more likely than not compressed his venous cava and also contributed to reduced blood return to his heart and reduced cardiac output and impaired ability to correct or keep a normal blood pH. More likely than not, both positions of the legs and compression of the back and neck contributed to a lower blood pH, which contributed to Mr. Aguirre's death, including the inducement of the fatal cardiac arrhythmia. The position was restrained in extreme anxiety and stimulated more production, which contributed to Mr. Aguirre's death while in the restrained position. The pressure to the back and neck applied by SAPD officers affected Mr. Aguirre's ability to breathe oxygen and expel carbon dioxide, and Mr. Aguirre's movements of his head from side to side prior to death were most likely attempts to expel carbon dioxide prior to his death while restrained. Dr. Mittler also noted that the use of stimulants, such as cocaine, may increase oxygen demand and muscle fatigue, and therefore may make this method of restraint even more dangerous. Taken in the light most favorable to plaintiffs, the summary judgment evidence indicates a reasonable officer in the officer's position would have known that applying the maximally restraint position to Aguirre and holding him in this position for an extended period posed a substantial risk of causing his death or serious bodily injury. In sum, facts material to whether the officers violated Aguirre's Fourth Amendment rights are genuinely disputed. The lack of visible resistance by Aguirre, the presence of numerous officers surrounding him, and the fact the officers had already blocked off several lanes and caused traffic to slow significantly, all weigh against the inference of any immediate safety threat or other need that would justify placing Aguirre in the prone maximally restrained position. A jury could conclude that no reasonable officer would have perceived Aguirre as posing an imminent threat to the officers or his own or the public safety, meaning that officers' use of what might have amounted to deadly force was necessarily excessive of any need to mitigate a public safety threat. Likewise, a jury could conclude that no reasonable officer on the scene would have thought that Aguirre was resisting arrest, meaning that the use of force far exceeded the amount necessary to effect Aguirre's arrest or ensure his safety. Notwithstanding the foregoing, we affirm the District Court's grant of summary judgment on the plaintiff's deliberate indifferent claims, unlike our inquiry into whether officers used excessive force, which judges the reasonableness of a particular use of force from the perspective of a reasonable officer on the scene, and a qualified immunity analysis, which asks whether the contours of the right are sufficiently clear. A reasonable official would understand what he's doing violates the right. The Fourth Amendment's deliberate indifference inquiry turns on law enforcement officials' subjective knowledge. Law enforcement officials violate the arrestee's 14th Amendment rights and when they have subjective knowledge of substantial risk of serious harm to a pretrial detainee but respond with deliberate indifference to that risk. Negligence, or even gross negligence, is not enough. The officials must have actual knowledge of a risk. On appeal, plaintiffs do not claim, much less offer evidence to demonstrate, that any of the officers were actually aware that Aguirre was losing consciousness or otherwise in danger. The officers have consistently asserted, and the video evidence does not indicate otherwise, that none of them knew that Aguirre was in medical distress until he became unresponsive. Of course they didn't, right? They stated that he continued to talk, yell, and move his head while on the ground so that they believed he was able to breathe. The officers testified they believed Aguirre's groaning and discolored lips were due to heavy drug use, not asphyxiation, and plaintiffs do not offer evidence to dispute these accounts. Even if the asserted beliefs were unreasonable and their actions contrary to what they should have known from training, that can only at most establish a gross negligence, not the required deliberate indifference. Because plaintiffs do not cite to, and we have not identified any evidence that the defendant officers were aware that Aguirre was in danger until he became unresponsive, we affirm the District Court's grant of summary judgment on that claim. Thus, that brings us to our end of the discussion of the Fifth Circuit case of estate of Jesse Aguirre versus the City of San Antonio. In this case, the City of San Antonio put someone in a prone position and it killed them. And there's a question as to whether the police are responsible. The Court of Appeals looks over the relevant factors and says that, as to some of it, that the officers were not in a position to know any better. so that there is no liability here. So that was a different decision than you might have expected, but at least for the moment, that brings us to the end discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.